The Federal High Court in Abuja under Justice James Omotosho has dismissed the no-case submission filed by Nnamdi Kanu, leader of the Proscribed Indigenous People of Biafra (IPOB), against the terrorism charges brought by the federal government. The judge ruled that the Department of State Service (DSS), acting for the government, had established a prima facie case requiring Kanu to open his defense. Kanu's legal team, led by Chief Kanu Agbabi, had argued that the prosecution failed to link him to any act of terrorism, noting that none of the 5 DSS witnesses testified to being incited by him, and that his statements were never properly investigated.
The judge made a ruling that there's a prima facie evidence that needs to be explained. So in common parlance, it calls on him to come and mount his own defense. But there is the other aspect of the ruling that concerned extraordinary rendition. That very one is one that compounded us, because the extraordinary rendition of Mazi Nnamdi Kanu is so open and notorious. 2 international institutions or 2 separate panels of the United Nations have made pronouncements regarding his extraordinary rendition and called for his unconditional release. Nigeria is a member of the United Nations and therefore bound to consider that and implement that decision. And in Nigeria here, 3 courts have made similar pronouncements. First was by the Federal High Court of Umuahia, which awarded him 500 million naira. And the Court of Appeal also pronounced that he was a victim of extraordinary rendition. And in the Supreme Court, the same Supreme Court that sent this case back to trial, reached the same conclusion, that he was a victim of extraordinary rendition. And all these things are of the record. They are all in the file. And we remember when this trial was being conducted, these very documents were tendered in evidence. So it compounded us, it confused us, that the court now made a pronouncement that the extraordinary rendition had no evidence before the court, that no evidence of it was submitted before the court. And you remember, least but not the last, recently a Kenyan High Court made the same pronouncement. But well, if the court was misled by believing by mistake that these things were not in evidence, it also said and left the door open that such evidence be submitted. So we are coming back with that evidence, and it's going to be quantum and legion.
They also pointed out that the charges were amended 8 times without evidence of incitement and described as alleged threats as mere boasting. The prosecution, represented by Chief Adegboyega Awomolo, countered that of Kanu's public broadcast on Biafra radio were deliberate threats to Nigeria's unity, caused fear among citizens, and therefore should not be dismissed as empty words. Alongside the ruling, Justice Omotosho ordered the Nigeria Medical Association (NMA) to constitute a panel of 8 days medical experts, including a cardiologist, neurologist, and the CMD of the National Hospital, to examine Kanu's health and report within 8 days. The decision follows conflicting reports from DSS doctors and Kanu's private consultants. The court adjourned the matter to October 8 to receive the medical report, after which a date will be fixed for the continuation of trial. Kanu has been in detention since his return from Kenya in June 2021.